look at the local regulatory matrix, which will be basically the same or similar in all EU and most countries, you will see that it is quite complex, it is quite incomprehensive, and it is quite contradictory in terms of various asset classes or product types, how they are treated by the regulations, depending on into what the wrapping solution is wrapped at the end of the day. Just briefly, and of course there may be different risks or different issues which will arise under the various pieces of legislation, because if you look at the securities regulations, then of course you will have the set of rules which are contained in the prospectus directive and its implementation, and in addition in the relevant rules which will apply, which are contained in Poland in the Act on Trading in Financial Instruments. So basically you will have in essence you will have MiFID plus the prospectus directive with which you have to comply, and these rules may be viewed in many cases as the most comprehensive ones. So the level of protection may be, in many cases, the most comprehensive ones the retail investors will enjoy. But these rules will not apply in the case of insurance regulations, or in the case of other, for instance, banking regulations, where the regulation, the legislation is less restrictive and is less detailed. Basically, the least detailed regulation, in my view, is the insurance regulation, at least as far as the retail investors' rights are concerned, because there are, of course, this guidance which Jakub mentioned, but they are not at the end of the day binding law. The legislative or regulatory initiatives which we briefly mentioned are aimed at leveling or equalizing the level fields in the case of many of the aspects of the products, in particular in the case of the disclosure, because for instance the insurance regulation doesn't in fact contain a detailed rule about how you should present the structured product or the derivative instrument embedded into a structured product. On the other hand, you also have the investment funds regulation, which are also quite comprehensive, and especially when UCITS 4 enters into force, then you will have a regulation which is the benchmark for the PRIPS, at least in terms of the disclosure level requirement, the KIT, the KIT document. So there are various classes. I mean, there are various risks, of course, involved for various product types, and these risks are. I mean, where there is less regulation, then of course there is a question where the consumer protection laws will come into play, and generally they will come into play in most of the types of the products. Less so probably in the case of the securities. Legislation. So if you have a structured product crafted as for instance structured bond or structured note, then the legislation contained in MiFID implementation and the prospectus directive is in many cases self-contained, but still there are certain consumer protection laws that will apply. But for instance, in relation to insurance product, of course, the intervention rights of the Polish regulator, of the Polish consumer protection regulator, are more important and are more likely to be triggered because as I said, the general rules applicable to contract law will be invoked by the regulator to protect the investors, because there is no detailed set of rules applicable to insurance products. And for instance, the regulator reviewed or is reviewing the standard agreements for IKE, for individual pension accounts, and we are also aware that the consumer protection regulator is quite interested in protecting, for instance, buyers of insurance products, structured products, and some of the unsatisfied customers are, for instance, seeking protection from the WOKiK. You should bear in mind that there is a class action legislation in Poland in force. there have been rumors about it being threatened by some dissatisfied investors. Basically, distributors could be on the hook, or product manufacturers. But of course, mostly it will be about disclosure, right, and about the risks and about the costs. So these are the two areas where you should be most diligent about, which is probably quite obvious. And there will be also various contractual interrelations between various parties involved in the process. So in addition to the exposure to the entire market, which will be basically on the side of the distributors and product manufacturers, there are also contractual relations, potential recourse claims, and so on between various relevant parties, including product providers or wrapping solution providers.